This is Zero Daze. I'm Chloe Kingman.
And I'm Owen Albright.
Sometime before this administration took office, a man named Luis Elizondo sat down and wrote a proposal for a job. Not an application, a job description. He recommended that the federal government stop scattering the unidentified anomalous phenomena question across a dozen agencies and put one senior official in charge of it, seated inside the National Security Council.
And in the 18 months since, that office has gone from a paragraph in a policy brief to something people in this field talk about as though the chair already exists and is waiting for someone to sit in it.
In late July of 2026, Elizondo packed up his house in Wyoming and moved to Washington. He announced it himself, on camera, filming from his truck at a rest stop partway through the drive. He said fighting for disclosure is a full-time job.
He has not confirmed that a position is coming. He has also never said that no such position is under discussion. Those are two different silences, and it is worth keeping them apart.
So this episode is about a job, and about the two men whose names are attached to it. Because while Elizondo was drafting an office in the executive branch, David Grusch went through a different door entirely, and he got there first.
Grusch has been drawing a congressional paycheck since the spring of 2025. He is a special advisor on this exact subject to a sitting member of the House, which means the most famous witness of the modern era is now staff. That was announced in a press release, and almost nobody treated it as the significant development it is.
Let me start with the proposal itself, because the reporting on this has been loose, and the document is more specific than the coverage.
What Elizondo submitted was a policy brief to the incoming administration. It recommended creating a czar for emerging and disruptive technologies, with unidentified anomalous phenomena explicitly named in the portfolio. Not a study group, not another office inside the Pentagon, a position seated in the National Security Council.
And the duties as described are coordination duties. The person in that seat would coordinate the federal response across departments and lead the relevant discussions at National Security Council and cabinet level.
Read that plainly and you understand why it appeals to people who have spent years frustrated. Right now this subject is split between Aero at the Pentagon, the intelligence agencies, and 2 or 3 congressional committees, and every one of them can tell you the answer lives somewhere else.
That is not a rhetorical complaint. That is the documented obstacle. We covered it when the Department of Energy and the Central Intelligence Agency tranches came out, and neither agency would answer for the other.
So a coordinating authority is the ordinary Washington answer to that problem. If nobody owns a question, you give it an owner. That is not a conspiracy. That is org chart hygiene, and it is how the government has handled everything from pandemic response to drug policy.
Here is the other half of it, and both halves are real. A single office with the authority to coordinate disclosure is a single office with the authority to meter it.
The same choke point that ends the runaround can end the leaks. If everything routes through one desk, then whoever holds that desk decides the sequence, decides the content, and decides the timing of anything the executive branch chooses to release.
And that is the tension this whole episode sits inside. The mechanism that could finally force the agencies to answer is the same mechanism that could finally make sure they never have to.
Nothing about proposing that office is improper, either. If you believe fragmentation is the problem, recommending a coordinator is the obvious fix. And the person best placed to describe the office is usually the person who thought it through.
Which brings us to the move. In late July of this year, Elizondo relocated permanently from Wyoming to the Washington area.
The rumor that attached itself to that move is that he is being lined up for the National Security Council role. That has not been verified by any outlet. No appointment has been announced. Elizondo has not asserted one.
What he has not done is say there is no such position under discussion. And I want to be careful here, because the absence of a denial is not evidence of anything. People decline to comment on personnel matters constantly, and most of the time it means nothing at all.
But assembled in order, the sequence is a man who proposed a job, declined to confirm or rule out receiving it, and then moved to the city where it would be performed.
Every one of those facts is innocent on its own. I want to say that clearly, because it would be easy to narrate that list in a tone that does the arguing for you.
People who care about a policy area move to Washington to work on it. That is what Washington is. If everyone who relocated to the capital to pursue an issue were suspect, the city would be empty.
So hold the sequence without the tone, and let it sit next to what the other man did.
In March of 2025, Representative Eric Burleson announced that David Grusch would join his office as a special advisor on unidentified anomalous phenomena, effective that April.
And as part of that arrangement, Grusch's security clearance was reinstated. That matters more than it sounds, because he had spent the previous 2 years as a private citizen whose clearance had been pulled and then restored on appeal.
So consider where the two of them now sit. Grusch advises a member of the legislative branch, and that branch has spent 3 years trying to pry records out of the executive.
And Elizondo is the name attached to an executive branch office that would decide what the legislative branch receives.
If both arrangements hold, the two most prominent witnesses of this decade end up on opposite ends of the same oversight relationship. One of them asking, one of them answering.
That is not a feud. Neither man has said an unkind word about the other in public. It is something more interesting than a feud, which is a structural position.
Now, if someone is going to hold an office like that, drawn from this community rather than from the agencies, the first question anyone will ask is what his actual record is. And that is where Elizondo has an argument he has never resolved.
The biography his side filed with the House Oversight Committee for his testimony on November 13, 2024, says that by 2012 he was, quote, the senior ranking person of the Department of Defense's Advanced Aerospace Threat Identification Program.
That is a tip. And the Department of Defense has said the opposite of that for years, in the same words each time. The spokesperson Susan Goff has stated that Elizondo had no assigned responsibilities for A-TIP while he was in the office of the Under Secretary of Defense for Intelligence.
Two statements, both on the record, and they cannot both be describing the same arrangement. Either the department is using the phrase assigned responsibilities in a narrow personnel file sense that excludes work a person genuinely did, or the claim of program leadership is inflated. Those are the only two doors, and nobody has walked us through either one.
When a memo from Senator Harry Reid surfaced from 2009 that appeared to bear on the program, the department confirmed the memo was authentic and said it changed nothing about that assessment.
What has emerged since sits closer to the department's version, and it emerged through records requests, rather than through anybody's press release.
Defense Department emails released to the Black Vault and published last year record an official in 2019 describing Elizondo's contribution as connections and introductions to other Pentagon elements, office and small group meetings, advice and correspondences.
And the same material states there were no funding lines associated with his work, and no significant resources expended.
That is a description of informal coordination. It is not a description of command of a funded program. It is one internal characterization, written years after the fact, by someone with their own position to protect, and it deserves to be weighed as such.
But it is the documentary record that has actually surfaced, and it does not match the biography that was filed with a congressional committee.
There is one more thing about this dispute that people tend not to mention, and I think it belongs in the record.
Go ahead.
In August of 2022, John Greenwald of the Black Vault announced a podcast episode examining Elizondo's Inspector General complaint. Elizondo's attorney at the time, Todd McMurtry, posted publicly that the directorship was well documented and that any participation in a plan to cast doubt on it was a knowing effort to defame and sow disinformation. He said it was legally actionable.
Greenwald is a documents researcher. His entire method is filing Freedom of Information Act requests and publishing whatever comes back.
So the warning was aimed at a man whose practice is releasing the government's own paperwork. That is worth noticing regardless of what you think about the underlying question.
And there is a second complication on the credential, which comes from the government's own history of the program rather than from anyone's lawyer.
The All-Domain Anomaly Resolution Office published the first volume of its historical record report in March of 2024. Its account of A-TIP and its predecessor contract is stranger than the shorthand suggests.
The report describes exploratory papers across 12 scientific areas that were never thoroughly peer-reviewed. It describes the effort investigating an alleged hotspot of anomalous activity at a property in Utah, including reports of shadow figures and creatures.
It records that there were plans to hire psychics to study interdimensional phenomena, and it states that the Defense Intelligence Agency did not seek nor specifically authorize that work. Though a Defense Intelligence Agency employee set up and managed the contract, The program was terminated in 2012.
The property in Utah is Skinwalker Ranch. We spent a whole episode on how that contract came to exist and who paid for it.
So whether leading that program is a qualification for running the federal response depends entirely on which description of the program you accept. And both descriptions come from the documented record.
Let's go back further, because the career before the file is relevant, and it is not what most listeners picture.
From the biography filed with Congress, he enlisted in the Army in 1995. In 1998, he was recruited as a civilian intelligence officer into a sensitive Department of Defense program. After September 11th, he served as an intelligence officer supporting Special Operations and General James Mattis during Operation Enduring Freedom.
Then counter-espionage and counter-terrorism investigations as a special agent in charge. Then the Office of the National Counterintelligence Executive. Then the Office of the Director of National Intelligence.
And in 2008 he was brought back to the Pentagon and assigned as Director, National Programs Special Management Staff, inside the Office of the Undersecretary of Defense for Intelligence. In that role, he says he managed a special access program on behalf of the White House and the National Security Council.
One precision, because this circulates loosely and gets upgraded every time it is repeated. The record says support to special operations. That is the biography's own phrase.
There is no documented command relationship with Joint Special Operations Command in any of the material available. People say it. The paperwork does not.
What the congressional biography leaves out entirely is Guantanamo. And we know about Guantanamo because Elizondo tells us himself.
Accounts place him running intelligence operations at Camp 7, which was the most restricted facility in that complex. Built to hold the high-value detainees who were transferred out of Central Intelligence Agency custody in 2006.
In his book Imminent, he writes that an attorney for one of the September 11th defendants called him the United States Czar of torture in open court. He writes that he was informed of a European arrest warrant covering those involved in the rendition, detention, and interrogation program.
His stated justification is that he was serving his country and preventing another attack. That is his account in his own book, and readers can weigh it however they weigh it.
I am not going to editorialize about it. What I will do is name the structural fact underneath it, because it bears directly on the job we started with.
This is a counterintelligence career, and counterintelligence is the professional discipline of managing what other people believe.
The man who became the public face of disclosure spent 2 decades in the business of controlling information, including at the most secretive end of the detention system. That is not a disqualification. It is context you are entitled to have.
And he does not hide it. This is the part that surprised me most when I went back to the primary documents.
Say it.
In his written testimony to the House Oversight Committee, on November 13th of 2024, Elizondo told Congress, quote, "For many years, I was entrusted with protecting some of our nation's most sensitive programs."
Under his own name, in a document submitted to a congressional committee. Program protection is what he says he did for many years, and he offers it as a credential rather than as an admission. It is the thing that makes him credible on the subject of secrecy, and it is also the thing that will be used against him.
Hold that sentence, because we are going to need it later, and it is going to sit underneath an allegation made about him this summer.
There is one more thing in that career history, and it is a name, and I think it is the most under-examined detail in this entire story. It is sitting in plain sight in his own biography, and once you see it, you cannot stop seeing it.
In 2008, when Elizondo was assigned into the office of the Undersecretary of Defense for Intelligence, the man running that office was James Clapper.
Clapper was confirmed as Undersecretary of Defense for Intelligence in April of 2007 and held it until the summer of 2010, when he moved to Director of National Intelligence.
So Elizondo arrived in the directorate Clapper ran, and served roughly 2 years inside it, in the same window that the Skinwalker contract was standing up.
On March 12, 2013, Senator Ron Wyden asked Clapper, in an open Senate Intelligence Committee hearing, whether the National Security Agency collected any type of data at all on millions or hundreds of millions of Americans.
Clapper answered, "No, sir," not wittingly. He added that there were cases where the agency could inadvertently collect, but not wittingly. That is the whole exchange. It took about 15 seconds, and it is probably the most consequential 15 seconds of congressional testimony about surveillance in the modern era.
The Snowden disclosures 3 months later established that bulk collection of American telephone metadata was underway.
Clapper later described his own answer as the least untruthful one available to him. Later still he called it clearly erroneous. Wyden's office has said that Clapper's staff privately recognized the problem within days, while taking 14 weeks to correct the record formally.
No charge was ever brought. The Justice Department did not pursue it, the committee did not refer it, and Clapper served out the remainder of his tenure as Director of National Intelligence and retired on schedule. The record simply absorbed it.
I want to be extremely careful with what that does and does not mean, because it would be easy to run it as an insinuation, and it is not one.
Guilt does not travel through an organizational chart. Nothing in the record suggests Elizondo had any part in that testimony or knew anything about it, and it would be dishonest to imply otherwise.
The relevance is to the argument, not to the man. The case for putting one senior official in charge of this subject rests on trusting that official to decide what the public learns and when.
And the last time this apparatus was asked a direct question under oath about domestic collection, the answer was untrue. The correction took 14 weeks, and the consequence was nothing.
That is the institutional culture these disclosure claims come out of. It does not settle anything about the claims. It is a reasonable thing for a listener to weigh when someone asks them to accept an insider's word in place of paperwork.
Now I want to talk about something almost nobody covers, which is that this movement has a structure. It gets described as a loose community of witnesses and podcasters, and that is not accurate.
There is a legal and political apparatus, and a surprising amount of it runs through one attorney.
Daniel Sheehan, constitutional lawyer, decades of public interest litigation behind him. He served as general counsel to Luis Elizondo.
And in May of 2021, it was Sheehan who filed the 64-page complaint with the Department of Defense Inspector General on Elizondo's behalf, alleging coordinated disinformation and reprisal by senior officials.
In 2023, Sheehan founded the New Paradigm Institute as a program of the Romero Institute, which is the Law and Public Policy Center he runs out of 210 High Street in Santa Cruz, California.
In February of 2024, the Institute launched something called Citizens for Disclosure, which organizes supporters inside their own congressional districts to press their representatives.
And I want to be precise about what that is, because the shorthand gets it wrong. It is described in its own materials as a citizen mobilization campaign. There is no federal election filing under that name that we could find.
So it is district-level organizing. It is not a political action committee that raises and spends money on candidates, and calling it one would be sloppy.
Alongside it, the Institute has run voter contact drives, publicly pressured members of Congress over the Schumer and Rounds disclosure legislation, and opened a Washington office to lobby.
Put the picture together. An advocacy organization headquartered in Santa Cruz, with a Washington lobbying presence and a district-level organizing arm. Founded by the lawyer who served as general counsel to the man now associated with a proposed executive branch office, campaigning for the legislation that would govern the subject.
None of that is a scandal. I want to be emphatic about it. That is what an organized political interest looks like, and Washington is built out of them. Environmental groups do it. Defense contractors do it. Everybody does it.
It is worth saying out loud only because the movement's rhetorical position is that it stands outside the system. And this is what standing inside it looks like.
Now the board changed in July, and this is the part that has not been metabolized yet.
In late July of 2026, the President directed the Department of Defense and the intelligence community to waive prior non-disclosure agreements for current and former employees and contractors who hold information about unidentified anomalous phenomena.
The mechanism is that those people can speak to authorized representatives of AERO or of the President's task force on the subject without legal jeopardy. Intelligence community elements were given 30 days to coordinate with the Office of the Director of National Intelligence and name a designee.
This is the thing the community has demanded for years. People who said they could not speak because of the agreements they signed now have a route.
And it is narrower than the headlines made it sound. It is not a declassification order.
Correct. It removes the legal barrier that kept witnesses quiet, and it routes them to cleared government investigators. Anything they say still passes through the existing review process before any of it reaches the public.
So the agreements are waived. The information is not released. Those are separate questions and the directive only answers the first one.
Representative Eric Burleson, who has been calling for exactly this, welcomed it on July 29th. And then he said something that got almost no attention.
His office had asked to see the directive and had not been shown it. A congressman who spent years demanding exactly this policy welcomed it publicly, while acknowledging he had not been permitted to read the document that created it. That is a strange position for an oversight body to occupy on its own signature issue.
He wrote that they are uncertain whether the abrogation of the agreements will apply to testimony received by Congress before referral to the executive branch. And he advised anyone thinking about speaking to the executive branch to bring not only an attorney, but a member of Congress into the room with them.
Read that again slowly. That is a sitting congressman telling potential whistleblowers not to walk into the executive branch channel alone.
And the special advisor on this subject sitting inside that office is David Grusch, the man who told Congress in 2023 that information was being withheld from its now staff to the member, warning witnesses that the executive branch channel may not protect what they say to Congress.
So the two men we started with are now on opposite sides of a live procedural fight about who receives whistleblower testimony. That is a far more concrete disagreement than anything either of them has ever said about the other.
It also tells you the stakes of the office we opened with. If a coordinator is appointed inside the National Security Council, that person sits at the top of the channel Burleson is warning people about.
Before we get to the allegation, there is an update that bears directly on what a protected channel is worth, and it involves two names this show has covered separately.
Matthew Brown, who wrote the Immaculate Constellation report, and Dylan Borland, the former Air Force geospatial intelligence specialist who says reporting what he saw at Langley cost him his career.
On September 9th of 2025, Borland testified before the House Oversight Task Force on the declassification of federal secrets at a hearing titled Restoring Public Trust through UAP Transparency and Whistleblower Protection.
Note the title of that hearing. Whistleblower protection was not a side issue. It was half the stated purpose of the proceeding.
Brown says that after that hearing he was invited to Liberty Crossing, which is a major intelligence campus in the Washington area operated by the Office of the Director of National Intelligence.
By his account, he was told his clearances were active, that the meeting would be fully protected, and that a formal whistleblower protection program for this subject would be offered to him.
And by his account, none of that happened. He says the program was never mentioned in the room, never offered, and no paperwork was put in front of him.
That is Brown's description of the meeting, and we have no independent record of what was said inside it. The Office of the Director of National Intelligence has not given a public account of that conversation.
What is not in dispute is what the two of them did next. Brown and Borland launched a nonprofit called Vanguard, built to do two things the government has not.
Pursue disclosure through the courts by filing suit to compel answers onto the public record where Congress has stalled, and provide direct material support to witnesses, which Brown has described as a gap nobody was filling.
A whistleblower protection fund founded by whistleblowers because the protection they were told to expect did not arrive.
And I want to put that next to the directive we just discussed, because the two things are the same question asked twice.
The directive says a witness can now speak to cleared investigators without legal jeopardy. That is a promise about how a channel will behave.
The last time a witness in this subject was promised, in person, at an intelligence facility, that a formal protection program would be extended to him. His account is that it never materialized. Nobody has been asked to explain that, and no one has.
So when Burleson tells people to bring a member of Congress into the room with them, he is not being paranoid. He is describing a documented gap between what witnesses are told and what they receive.
There is a live thread here too. On March 31st of 2026, the task force wrote to the Secretary of Defense asking for 4 specific UAP video files, and said plainly that whistleblowers had informed it that Aero holds additional video records.
The committee gave a deadline of April 14th and stated that Aero's previous responses, when questioned about sightings and the data behind them, had been less than adequate.
Which is a congressional task force saying, in a letter, that the office built to resolve this subject has not been answering it. That is the machine the coordinator we opened with would sit on top of.
Which brings us to the allegation. Because somebody said all of this out loud this summer, and it caused a considerable amount of noise.
In late July, an independent researcher who works under the name UAP Czar told the journalist Ross Coulthart on News Nation that before Elizondo went public he had worked in technology and program protection for the legacy programs, and that he is now being positioned for the National Security Council role specifically in order to deliver a limited and managed disclosure.
Gerb produced no documents. The account rests on unnamed sources, and it has not been independently verified. The outlets that covered it said so directly.
Elizondo rejected it. He said the claims are built on false information and noted that he had given Gerb his phone number and never received a call. He also faulted outlets for running the allegations without more checking.
One disclosure of our own, because you should hear it from us rather than find it out. Stranger Than Fiction has cited Gerb's document research in previous reporting.
He is an independent researcher with no affiliation to this publication, and his claim gets handled the same way anybody else's does. We do not grade a source more generously because his work has been useful to us before.
Now here is why the first half of that allegation lands harder than an unsourced claim usually would.
Because Elizondo has described the underlying role himself. Program protection is what he told Congress he did, in his written testimony, under his own name.
For many years, I was entrusted with protecting some of our nation's most sensitive programs.
So the distance between that sentence and Gerb's version is not a distance of fact. Both of them agree about what the job was. The disagreement is about when it stopped. And why.
And neither side has produced a document that fixes either one. Gerb has not shown that the protective function continued past 2017. Elizondo has not produced records showing that it ended.
I want to make the strongest case I can that Gerb is wrong, because it deserves to be made, and because most coverage has not made it.
Make it.
Every fact that thesis rests on fits an innocent reading equally well. A person who spent 9 years arguing that the system suppresses witnesses, offered a seat where he could force the agencies to comply with a directive that frees them, would be negligent to turn it down.
Fragmentation is the documented obstacle. A coordinating authority is the standard remedy. Proposing that office and then being considered for it is what subject matter expertise looks like from the outside.
Taking a job is not proof of being bought, and what Gerb has offered is the sequence, and the sequence alone.
There is also a test coming that neither of them can stage manage, and I think it is the most useful thing in this entire story.
The directive creates an authorized channel. Somebody bound by secrecy agreements can now speak to cleared investigators without legal exposure. Elizondo has said for years that his own account is constrained by what he is still not permitted to say.
So if he walks through that channel himself, if he submits to an authorized debrief under the waiver, and does it while holding or seeking a government position, that is a costly and verifiable act.
And it is an act that a person running a managed narrative has no reason at all to perform. He would become the most prominent figure to actually use the mechanism rather than campaign for it.
If instead the visible effect of the directive is that witnesses go into an executive process, get reviewed, and are never heard from again, then Gerb gains ground without having to prove anything.
Both futures are still available, and the difference between them will be visible inside a year, which almost nothing in this subject ever is.
There is one piece of the record that complicates the generous reading, and it does not come from Gerb at all.
It comes from the Immaculate Constellation file, Matthew Brown, the former Department of Defense and State Department advisor who wrote that report and later identified himself as its author, describes the alleged program in his own text.
He calls it an unacknowledged special access program established after the exposure of a tip in 2017 by former Under Secretary of Defense for Intelligence Officer Lou Elizondo.
Sit with that, because it points in 2 directions at once, and which direction you take it tells you more about your priors than about the evidence. That one sentence is doing an enormous amount of work for both sides of this argument simultaneously.
Brown is claiming that the institutional response to Elizondo's disclosure was to build a tighter compartment, that the leak produced more secrecy, not less.
For Gerb, that is the pattern repeating, a disclosure event that ends in consolidation.
For Elizondo, it is the opposite reading and honestly the stronger one. A program built specifically to contain the damage he caused is evidence that the damage was real.
Brown's claim is uncorroborated, and the status of that document is contested. What it establishes here is narrower than either side would like.
The last time Elizondo produced a disclosure event, the alleged institutional response was a new compartment. And that is the precedent whoever takes this office would inherit in either version of the story. Before we get to how these two relate to each other, I owe you the other half of the balance sheet. We have spent a long time on Elizondo's contested record. Grusch has one too, and it is uglier in a different way.
Start with what he actually did, because it gets skipped constantly. Grusch did not go to a podcast. In May of 2022, he filed a formal disclosure of urgent concern and complaint of reprisal with the Intelligence Community Inspector General. That is the lawful channel. That is the one the system tells people to use.
And in July of 2022, the Inspector General found his complaint credible and urgent. That is not a figure of speech. It is a statutory finding, made by the government's own watchdog, and it obligated notification of the Director of National Intelligence and the Congressional Intelligence Committees.
So as of July 2022, an officer with a clean record had used the correct procedure and been formally told by the government that his concerns were credible and urgent.
On the 29th of August, 2022, he received notice that his security clearance was being revoked.
6 weeks. I want to let that sit rather than characterize it, because the dates are not in dispute and they do not need any help from me.
The revocation was finalized that December, and in January of 2023, an appeals board overturned it, and his clearance was restored.
That is the part that almost never gets reported, and it is the most important sentence in this section. The original revocation did not survive review. The system looked at its own decision and reversed it.
Then he testified under oath, in public in July of 2023, and a few weeks after that, The Intercept published law enforcement records it had obtained under the Virginia Freedom of Information Act.
A police report from 2014 concerning an incident at a property he owned, and records showing that in October of 2018 he was committed to a mental health facility following a report that he had made a suicidal statement.
He has connected that period to post-traumatic stress, to grief, and to alcohol. He is a combat-era intelligence officer who had a bad few years and got help. That describes an enormous number of people who served.
Grusch called it a smear and sued over the release, arguing it breached his privacy under Virginia law. The reporter's position is that these were public law enforcement records obtained through a lawful request, and not leaked medical files.
And that is true. It is also, on its own, an answer to a question nobody asked. The question is not whether the records could be obtained. The question is why somebody went and obtained them, in that county, about that man, in that particular month.
Nothing about it required anyone to break a law. Somebody decided which jurisdiction to file in, and what to ask for, and when to publish. Legality describes the method. It does not describe the intent, and it never has.
Here is the shape of what happened to him, and I am going to state it as a sequence rather than as an accusation, because the sequence is documented and an accusation would not be.
He used the lawful channel. The watchdog agreed with him. His clearance was pulled weeks later. An appeals board reversed that. He testified under oath. His psychiatric history was published.
Every step of that is on the record. What is not on the record is a single name. Nobody has been identified as having made any of it happen, and nobody has been held to account for any of it.
There is one more formal finding, and it went against him. I want to state it precisely, including the part that cuts the other way.
A heavily redacted Department of Defense Inspector General report on a whistleblower reprisal investigation, closed in February of 2025, found that the complainant's protected disclosures were not a contributing factor in the revocation of their clearance.
It concluded officials would have taken the same action regardless, and attributed the revocation to substantiated findings of what it called a pattern of misconduct.
And those findings have never been published, not redacted and released, not summarized, not shown to the man they describe in any form he can answer.
Which means the justification for the most damaging thing done to him is a phrase in a sealed file. You cannot reboot a pattern of misconduct that nobody will let you see, and no journalist can check it either.
It also sits awkwardly next to the appeals board, which looked at that same revocation and overturned it. Two arms of the same government reviewed the same decision and reached opposite conclusions, and only one of them has to show its work.
The caution most coverage drops, and we will not. The complainant in that report is redacted throughout and never named. The dates line up with Grusch's clearance history, and that is how the identification is made.
So it is an inference from a timeline, not a confirmation in the document. We are telling you how we know, because that is the difference between reporting something and repeating it.
And for the symmetry, because it matters. Elizondo filed a reprisal complaint in 2021 and it was not substantiated either. 2 men, 2 allegations of retaliation, 2 findings against them.
In neither case did anyone lose a job, face a penalty, or get named. Whatever else the record shows, it does not show a system that has ever found itself at fault on this subject.
Before we close, I want to knock down the idea that these 2 men are rivals, because the framing keeps showing up and the record does not support it.
Their government tenures never overlapped. Elizondo resigned in October of 2017. Grusch became the National Reconnaissance Office representative to the task force in 2019, moved to the National Geospatial Intelligence Agency in late 2021 as its co-lead for analysis, and left government entirely in April of 2023.
And Leslie Keane, who reported both men's stories 6 years apart, has said the programs they describe are completely separate.
But there is one claimed overlap between them, and it is not a rumor or an offhand podcast remark. It is sworn testimony given to a congressional committee, and as far as I can tell, nobody has ever followed up on it.
At the November 2024 hearing, Representative Tim Burchett asked Elizondo whether he was familiar with David Grusch. Elizondo answered, "Absolutely, sir. I had the privilege and honor of working with him myself several years ago at United States Space Force."
That is the only assertion of a direct working relationship between the two of them that exists anywhere in the public record. Not a claim that they met, or corresponded, or knew of each other. A claim that they worked together, made under oath, by the one of them whose job title is in dispute.
We are adding this late. The claim in it surfaced while this episode was being finished, and it bears directly on the sentence you just heard.
Danny Sheehan sat for a long interview with Andy McGrillen on that UFO podcast, published on August 6. Sheehan is the attorney who represented Lou Elizondo in filing his complaint with the Inspector General of the Department of Defense, and he says he advised David Grusch to file his own report with the Inspector General of the intelligence community.
Before the claim, how to hold it, and Sheehan tells you himself. Asked why critics say he never produces anything actionable, he explained that as a trial attorney, he conveys what witnesses told him in the first person, declaring it as fact rather than restating who said it and when.
He is describing advocacy, not deception, and he says so plainly. But it means his assertions and his first-hand knowledge sound identical, and the listener has to separate them, because he does not.
McGrillen drew the same line in his own introduction. He said the allegations involve named individuals and should be treated as Sheehan's account unless and until they are independently corroborated. We are adopting that framing.
Here is the claim. Sheehan says that when the security clearances of Elizondo and Christopher Mellon were challenged over their role as sources for the New York Times story, the person assigned to review those clearances was David Grusch.
He places Grusch there by role. Grusch was the National Reconnaissance Office representative to the Pentagon task force, and Sheehan says that is why he was selected to conduct the review.
Sheehan says Grusch found that both men had been explicitly authorized by the Defense Office of Publication and Security Review to say what they said, and cleared them on that basis.
And that clearing them is when Grusch, in Sheehan's telling, started taking it from everybody else in the Department of Defense.
Weigh what that is. A single named source on camera from memory describing a clearance adjudication he was not party to. No document produced, no second account. Neither Elizondo nor Grusch has addressed it.
What it is not is anonymous, and it is not vague. It names a reviewer, a subject, a reason, and an outcome. That is specific enough to be checked.
If it holds, it revises the sentence you heard a moment ago. Elizondo's sworn answer to Representative Burchett was the only assertion of a working relationship between these two men in the public record. This would be a second crossing from the other direction, described by neither of them.
It also inverts the rivalry framing. That framing has the two men as competitors for the same chair. Sheehan is describing an arrangement in which one of them held the other's clearance and handed it back.
Sheehan makes a second claim that cuts against Elizondo. He says he advised him that he could not technically fall under the whistleblower statute because he had already resigned, and the statute requires a complaint filed during employment about retaliation suffered during employment.
A lawyer's distinction, not a character judgment. But it is his own former attorney putting a boundary around a word Elizondo's public identity rests on.
On the office we opened this episode with, Sheehan is blunt. He says there is no such post as UAP Czar. He says the position under discussion is Chief of Staff of a Governance Board, announced by the Department of Defense in late June, and that the nickname has been carrying weight the job description does not.
He says the announcement named a scientific advisory group under AV Loeb and left the board itself unaddressed. Who sits on it, and who chose them, went unstated. Sheehan expects the seats to go to the heads of the agencies that have held this material longest.
He calls the proposal a catch and kill, and credits the phrase to Matthew Brown, whose joint work with Dylan Borland we covered earlier in this episode. Sheehan's reading is that an executive-appointed board would draw whistleblowers into a channel the executive controls.
His constitutional argument is narrow and citable. The Senate passed a version of the UAP Disclosure Act creating a 9-person panel subject to Senate confirmation. Representative Burleson sought a comparable provision in the House. Sheehan reads Article 1, Section 8, Clause 14 as placing classification rules with Congress rather than the executive.
One of these is a document question, and we will pursue it. The board's composition should exist on paper somewhere. The clearance review may not, at least not anywhere public, and it is the one that matters most to this story. A clearance adjudication leaves a paper trail, and the two men best placed to confirm or correct it have so far said nothing.
And its edges matter. The Space Force was established in December of 2019, more than 2 years after Elizondo resigned from the Pentagon. So whatever that collaboration was, it postdates his departmental service and cannot describe the period he is known for.
He did not elaborate. Nobody in the room asked him to, and in the year and a half since, nobody has.
Burchett then put Grusch's crash retrieval and reverse engineering claim to him directly and asked whether he agreed with it. Elizondo said, "Yes, sir."
Which is a change. Before 2023 his public case centered on sensor data and observed craft behavior and largely stayed away from retrieval.
Where they still differ is interpretation. Pressed by Representative Anna Paulina Luna about Grusch's testimony describing interdimensional beings, Elizondo declined the question and said he was not qualified to speculate about points of origin.
So two accounts that started as different allegations have moved toward each other, and one of the men doing the moving has stated under oath that he worked with the other.
That is not evidence of coordination, and it should not be played as any. What it means is narrower. They are no longer independent tests of the same proposition in the way they were in 2023.
Which matters, because their mutual endorsement gets offered as corroboration constantly. When one of them backs the other, it is presented as two separate sources arriving at the same conclusion. If they work together, and if one has publicly affirmed the other's central claim, that is not what two independent sources look like.
And for balance, the substance is still unconfirmed. Opening that same hearing, Chairwoman Nancy Mace said that of the agencies the committee had dealt with, none had been able to substantiate the claims Grusch made the previous year, despite members questioning those agencies inside and outside the secure facility.
Failure to substantiate is not disproof. A committee that cannot get answers out of agencies is describing its own access as much as it is describing the claim.
It remains true that 18 months of congressional effort produced no corroboration on the record.
So what would actually move this? Let me lay out what I think is checkable, because there is more of it here than usual.
The office question answers itself on a schedule nobody controls. Either an appointment is announced or it is not. If one is, the occupant and the reporting line become public record.
The credential could be settled with a single document, a personnel record, a tasking order, an organizational chart placing Elizondo in a defined role over that program, or a full and searchable release containing none.
The department has asserted a negative for years without publishing the underlying records. Elizondo has asserted a positive without producing them either. That is a resolvable question that both parties are leaving unresolved.
The Space Force claim is the cheapest open question on this entire board, and nobody has asked it. What capacity was he in, under what arrangement, and does Grusch describe it the same way?
One follow-up question at one hearing would settle it. In a year and a half, nobody has put it.
For Grusch, movement comes from his witnesses. He gave names to the Inspector General and to Congress in classified session. Any one of them testifying publicly converts his account from a referral into corroboration.
And the last one is procedural. Does the Office of the Director of National Intelligence publish its guidance? And does the waiver cover testimony given to Congress? Burleson asked. As of now, he has not been told.
I do not think the useful question is whether Luis Elizondo deserves the job, and I notice that nearly all of the argument online is about exactly that: whether he is sincere, whether he is compromised, whether he is a hero or a plant. I think that argument is a distraction from something more important.
The useful question is whether the job should exist in the shape proposed. An office created to coordinate disclosure is an office that can schedule it.
And the argument for building one rests entirely on trusting whoever ends up occupying it. The people asking for that trust have spent a decade explaining, carefully and often correctly, why it should not be extended to officials in exactly that position.
Whether that office becomes the mechanism that finally opens the file or the last door closing on it depends on details that have not been written down yet.
And when they are written down, we will read them, and we will tell you what they say rather than what they mean. That is the whole job. Thank you for tuning in to this episode. At Zero Daze, we know you have many choices in where to get your information from. Our continued efforts rely on the actions of our subscribers, so please take a moment to like, comment, and subscribe, and hit the notification bell to be informed the moment a new episode is live. The full sourcing is in the article at strangerthanfiction.org. The link is in the description.